I'm John Leonard, corporate lawyer at Fairfield and Woods in Denver, Colorado. We've done a series of videos that our clients, friends of the firm, you as somebody surfing the internet, hopefully will find interesting. Most of them deal with businesses and how the legal aspects of how you run your business need to be understood and how you navigate that. So there's sections on raising money, hiring people, wills and trusts, how to prepare for your estate planning connected with your business. We have one on litigation, and we have one we're doing with my partner today, Jack Tanner, on receiverships. And we've already done a video on what a receivership is, why you as a lender or shareholder of a company that might not be run correctly ought to think about instituting receivership proceedings. We've talked about how that generally works. Today, we're going to compare and contrast a receivership over something that you might know more about. It is bankruptcy. So Jack, thanks for joining us. So you've already talked about getting the receivership up and going. I think a lot of people would think if a lender has a problem with a company, they just put them into bankruptcy, and this might be a better deal.
Right, and that's very topical because most lawyers are far more familiar with bankruptcies than they are with receiverships, and so when they see a problem, their first instinct is to run off to bankruptcy court. And just like the old cliche about if the only tool you have is a hammer, every problem looks like a nail. Sometimes receiverships can give you a better remedy, and it's another tool you got in your toolkit. You don't have just a hammer. I actually wrote an article about this for the Colorado Lawyer back in 2011, comparing and contrasting receiverships and bankruptcies. I would say this analytically for you, if you're interested in the legal side of it, it's pretty interesting in the sense that a receiver is just a judicial appointee, and it's all judicial branch issue. Bankruptcy's there's the bankruptcy code, there are bankruptcy rules, the sovereign is involved, the United States trustee is involved. There's a lot more bureaucracy associated with it. Receivership is a lot simpler, often a lot more elegant, and therefore less expensive. The rule of thumb I often think about is if your problem is really money, if you've got a good business plan and good management, and your problem is just you got upside down on money, bankruptcy might be a good idea. But if the problem is maybe the management itself, bankruptcy is a bad idea because it gives that same management even more power. You get a debtor in possession, they got the same kind of folks that got you in trouble in the first place now have even more power. Whereas a receiver can completely replace management overnight. If an owner goes in and convinces the court to appoint a receiver to run the company, you may leave some of that management still in place, but the receiver is now making the crucial decisions subject to court supervision.
Is a receivership quicker? In other words, if I was a lender and thinking about bankruptcy, does it take days, months, weeks, years to get into bankruptcy court where a receiver would be more streamlined?
Well, getting them started is about the same. The receiver might even take a little longer to get started because you've got to get a court to say yes, whereas a bankruptcy petition can just be filed. However, once they're started, a receivership is usually less expensive and quicker to resolution. Bankruptcies tend to take longer, and because of all these layers of bureaucracy, are a lot more expensive than a receivership.
Right. Now, talk about, I think a lot of receiverships, we end up selling assets, selling substantially all the assets of a company. Can you talk about selling free and clear of liens? And if I'm a creditor, foreclosure versus receivership versus bankruptcy, I guess is what I'm asking.
And in this regard, they're all the same because all three of them have the same effect, which is that the assets are sold, the buyer gets them free and clear of claims, liens, and encumbrances. Those claims, liens, and encumbrances attached to the sale proceeds, same order of dignity. So whether it's a 363 sale in bankruptcy or a foreclosure sale through the sheriff's office or a receivership sale through a receivership, the result in that regard is all the same. The buyer gets title free and clear. The lien holders now, their lien is on the sale proceeds rather than the collateral.
And so as a creditor, you're ambivalent on whether you would foreclose under your loan documents or get a receiver or a bank or go into bankruptcy?
Well, if all you're looking at is title coming out the back, yes, you're ambivalent. There's a lot of other factors that go into it. And that's when I quite frankly say, pick up the phone and call somebody who understands both sides of that analysis and can give you some good advice. Because there are times you want one or the other. But there are a lot of factors you got to consider. It's not just one thing you think about.
Well, what's the process to hire you? I pick up the phone and call and we start talking?
There you have it.
Well, we run conflicts perhaps.
I mean, yeah,
Okay.
conflicts, make sure you don't do the work. And I do find receivership work really interesting. It's very, it can be challenging because of the lack of structure. You don't have a one size fits all plan. Oh, it's this kind of bankruptcy. It goes in this little pigeonhole. In a receivership, a lot more flexibility.
Yeah, I guess the thing I've been most impressed with is you go in, you analyze the problem, and there's a custom fix.
Exactly.
And whereas foreclosure can be pretty clumsy, and you have this public sale and you get rock bottom prices, and probably similarly in bankruptcy.
Right. In receivership, you're much more likely both to get a higher gross and a higher net.
Great. Well, a short discussion on comparisons between foreclosing on property, bankruptcy, and getting a receivership. It's at least fodder for a phone call between you and Jack Tanner to talk about what the specific issue is and what the best solution might be. So thanks for joining us, and please check out our other videos and the other videos Jack has done on receiverships here today.